kind of a cheat sheet or a primer on liens, bonds, and stop payment notices. And that's what this looks like. I am going to be doing a PowerPoint presentation that summarizes it a little bit differently. So again, this is your takeaway to refer to later if you've forgotten one of the deadlines or whatever, anything that we've talked about. So over the years, I've tried to find a way to present liens, bonds, and stop payment notice rights in a comprehensive way that might make sense, and to try to compare them at the same time so that you get a kind of the hang of there are differences, but then there are similarities. And so this is so far the best I've come up with. So I'm going to share my screen now. It's a PowerPoint presentation. See if I did that right. Yes, can you all see that? And you should only be able to see liens, stop payment notices, and bond claims.
Yes.
Okay, cool. So, and it's very important to remember that when I talk about liens and stop payment notices, I am specifically talking about California law. Other states, most states do allow mechanics liens, but their laws are so different from ours. The notices, all of that are very different. Likewise, stop payment notices, I don't know any other state that allows that. And then we have payment bond claims, which is another way that protects your right to get paid. And we just have a few different laws here in California. And then there's also federal projects allow payment bond claims, and they have slightly different they have different timetables and different things that trigger your deadlines to try to preserve your right. So I'm going to try to cover them all, again, in a way that'll give you some insight as well as a comparison of how they differ. So private works. So in California and in most states, when you're talking types of projects, somebody will say, well, it's a private work project or a public works project or a federal project. Private project simply means it's being paid for by private money. Restaurants, offices, malls, stores, houses, apartment buildings, so long as they're not being financed by some sort of grant from the city. Those are all private works. We also have public works, again, California. And that I mean Caltrans, school districts, city buildings, courthouses, state buildings, offices. Sometimes you're doing a project that's located in a private building, but it's really the tenant improvement is being paid for by a government or a California public entity or government entity. And then the third ones are federal projects. Those are the things you see on Navy bases, Camp Pendleton. It's the U.S. government is the owner of the project. Again, you can have the U.S. government moving into offices in a privately held office building, but it's considered a federal project because they're paying for it. And so that's anything Army, Navy, Air Force, any bases, any camps, anything like that are all considered federal projects. You could have an airport project that's kind of a public works project, and then also perhaps because it's owned by the airport authority, but perhaps there's federal funding. So it gets a little bit confusing, but that's far beyond the scope that we can cover today. But I just wanted you to be aware that it usually means who's paying for it is the type of project it is. And then you can also have mixes. So on private projects, private works, you can have mechanics liens. That's a way, and we'll get into a little bit more detail in a second, that's a way you can preserve your right to get paid. So if you do work on a private project, you don't get paid from your customer, you have the right to do a mechanics lien so long as you followed all the procedural hoopla that comes before it. You also are allowed to do stop payment notices on a private project. And a stop payment notice is simply a letter you send out to the owner saying, hey, I'm not getting paid. And then the owner has to hold that money back from the general contractor. And again, there's some procedural things you have to do before this right triggers, but we'll get to that in a second. Now you notice my little chart here, I have mechanics liens under private works, but I don't have them under public works. That's because you cannot lien a publicly owned piece of property. There are no such thing as mechanics liens rights. But again, you have to understand who really owns the project. For example, I had a case once where my client was wiring a bunch of private hangar buildings for airplanes. It was located on a Port Authority property, but the project itself was private. And so we had to figure out how we could formulate the wording on the mechanics lien to not make it sound like we were liening the property that was underneath the building. So it gets kind of tricky sometimes. So stop payment notices in California are allowed on both private and public works. Payment bonds, that's your third way to secure payment. Payment bonds are optional for the owner to require on private projects. Sometimes the general requires payment bonds from its subcontractors that are doing a significant amount of work. The reason that private owners don't like to get payment bonds is simply because they cost money. I think they cost anywhere between 2 and 3% of the whole project value, so that can add up to a big chunk of change. So along with a payment bond, you usually hear it called a performance and payment bond or a labor and material bond or something like that. But basically it's a bond that's purchased by the contractor, and the payment part of that bond is for the benefit of paying anybody who provides services, materials, labor, equipment to that general contractor who doesn't get paid. And if you notice, payment bonds are also allowed in California public projects. They're not only allowed, but they're required. So where it's optional on a private project, by law, you have to post a payment performance bond for the full value of the whole contract if you are a prime contractor on a California Public Works project. So, I mean, that's really good to know, because that's a way that you can secure getting paid by a bond company if your customer bails out or fails to pay you. Federal projects also allow payment bonds, or they require by law the prime contractor to obtain a performance and payment bond. Again, the reason of the payment bond is to make sure that everybody who provides services, labor, material, whatever, through the general eventually gets paid. And if you notice, under federal projects, there are no mechanics liens, kind of the same reason you can't own federal project. And federal law does not recognize stop payment notices. But they do have payment bond requirements. So that's why that's why a comparison, I feel, is helpful depending on what kind of project you are going on. And each one of these payment, protections requires a slightly different way that you have to do early on to protect yourself. So for mechanics liens, there's something called a 20-day preliminary notice. And remember, these laws regarding mechanics liens are only California right now. If you do work in Nevada, Arizona, yeah, they have mechanics lien laws, but they're different as far as how you perfect them, how you enforce them, etc. So you really have to understand the lien laws in the state where you're going to work. If it's a federal project, doesn't matter where it is, their payment bond issues or the payment bond process is the same. So you need to do a 20-day preliminary notice, and that we'll get to that in a second of exactly what that is and why it's called a 20-day prelim. Same with stop payment notices, both on private and public. You have to have served a 20-day preliminary notice. Now, I'm going to do one more. Same with payment bonds in California. Not so with federal projects. You do not have to do a 20-day preliminary notice in a federal project. And so I'm going to tell you something and then you need to forget it. If you have a direct contract with the prime contractor, you do not need to do a 20-day prelim to have stop payment or bond rights. If you have a direct contract with the owner, you do not have to do a prelim for mechanics lien rights. Now you're going to forget that, because you're always going to do 20-day prelims, because that is the only way to make sure that your payment rights are secured if your customer, whether it be the owner or contractor, bails out, goes bankrupt or whatever. And there are many companies. A lot of people use Level Set, Level-set, Caprinos locally. There's a lot of companies who will do this for you for probably less than $100. So you really need to do your prelims, because that's in California, that's the way that opens the door to your other rights. So let's talk about a 20-day preliminary notice. The reason it's called a 20-day preliminary notice is because it intends for you to do this notice within 20 days of first day on the site. Well, what is first day on the site? Well, first day on the site is perhaps putting up temporary fencing, putting your job site trailer, whatever it is. The first day materials are delivered, the first day you have labor on site. So the rules intend that you will send this notice in within 20 days of first being on site. So preliminary is due 20 days later. So what happens if you do not send your preliminary notice until 60 days later? You just say, oh, I screwed up, I'm not going to do it. No, you go ahead and send it out as soon as you realize that you haven't. And what that does is it gives you lien rights the 20 days before you sent it. So your lien rights in a project where you forgot to send it and you waited 60 days, you'll be protected for the work you did or the materials you provided starting on day 40, because that's 20 days before. So you will not be protected with lien rights for the first 40 days. And you might say, oh, that's horrible. But in reality, we don't generally start seeing problems with getting paid until more than 40 days in, unless you're doing very fast projects. Even if you're in and out within 20 days, you still need to do a preliminary notice, in my opinion. They're cheap, they're easy, either do it in-house or go to one of these services that do it. Because 20 days will pass before you realize you're not getting paid. So even if you're doing a 3-week project, you're only out there for 15 days, still do your preliminary notice, even though you do it after you're done. It doesn't matter. It'll relate back 20 days before you send it in. Does that make sense to everybody? Because that is very, very important.
Yes, thank you for clarifying that.
Yeah, and if you are, what happened? Let me see if, no lien rights for the first days. Okay, so let me talk a little bit more about preliminary notices. At the beginning of the project, I'm telling you this, it is so much easier to get the owner's contact information, their address, who the owner is, who the lenders are. If you're doing a contract directly for an owner, you need to give the preliminary notice to the lender. If you're a subcontractor, you need to give a preliminary notice to the lender, because that allows them to understand, hey, you're out there, and if you don't get paid, you can do stop payment notice and stop those construction funds, or you can lien the project, which the lender's not going to want you to do. And you need to do it at the beginning of the project. If you wait 3 months into the project and the general contractor is late paying you, or the owner's not paying, or something's wrong in the payment chain, try to start asking them, so who's the lender? Who's your bond company? They're not going to want to tell you. And it's a pain in the butt to get that information when payment problems already start. So everybody should have a job information sheet that they make their customers fill out, and do it right when you're negotiating. And it should say project owner address, lender address, payment bond company address. And if it's blank and it's a public project on the payment bond, you know that's wrong. They have a payment bond. If you're a subcontractor, make the subcontractor get you that information. I cannot emphasize enough how much easier it is to get it at the beginning than when you're already having payment problems. And by law, you're supposed to be serving all these people with this preliminary notice. You're supposed to be sending them your preliminary notice. Again, if you don't know how to do them, contact a lien company, a prelim company, and they should be able to do it for you. So we're all going to go out and have the job info sheet. Again, I should have said project name and address, owner's name and address. If you're doing something for a tenant, you need the tenant's name and address, as well as the owner, who's probably the landlord's name and address. So if you're walking into an office building and you're doing a whole suite of offices for, Apple or Honeywell or Amazon or whoever, they probably don't own that building if there's other tenants. So you need to find out who the owner is, the tenant, lender, bond company, if there is one on the private. Does that make sense?
I have a question. This is Vanessa.
Sure.
So in that scenario, you would also prelim the tenant, even though they're not the owner of the building.
Absolutely. And the reason is because they're the owner of the project.
Gotcha. Okay.
And so, and the other thing is that, and this again gets into more detail than we have you may have a situation where the owner or the landlord post something that says they're not responsible to pay liens, and then you would only have the ability to go after the tenant.
Okay.
Yeah, so it's called a notice of non-responsibility. They got to jump through a bunch of hoops to make it valid. And so I ignore it when we lien a building and the owner goes, well, we did a notice of non-responsibility. I'm like, well, prove it. Prove it that you posted it within 10 days of the first person getting there. Prove that you put it with the county recorder or whatever they have to do. I can't even remember. That's their defense. But always do the tenant, because your lien rights attached based on the owner of the project ordering the work. And so, yeah.
And that was a notice of non-responsibility, you said?
Yeah, some owners, landlords will try to post that on the project. I ignore them because there's other ways you can get around it. For example, if a landlord is actually requiring the tenant to do the tenant improvements as a condition of their lease, or they're paying for part of it, then a lot of times those notices aren't valid.
Interesting. Okay.
Yeah, if you ever do a mechanics lien and they start telling you that it's invalid and all that, as long as you did a preliminary notice, I ignore it and say, okay, prove it.
Gotcha.
Because your lien rights come up really fast and you don't want to screw around with those. And so, and we'll get to the timing of those in a second. But my philosophy is go ahead and lien it. And if you're wrong, remove it as soon as you figure out you're wrong, because otherwise you're going to miss a deadline. But 20-day prelims are very important to have any of those rights. And again, even if you're doing work directly for the tenant or directly for the building owner, get in the habit of doing a prelim. Ask them if they have a construction lender that's financing part of the project, and get those prelims in. I actually have clients who will prelim in other states, and everybody freaks out because they don't need them, but better to be not sorry. Be overly cautious when it comes to lien rights.
Great, thank you.
You're welcome. Okay, so the next one, again, with payment bonds, 20-day prelim again. Payment bonds with Miller Act, you don't have to do it. There's a different kind of notice that you end up having to give there. And the details of all these little sections are on that handout that was sent to you either yesterday or today or whenever it was sent, the lien primer. And I tried to get pretty detailed there. It just makes for a boring presentation. I like the colors. So what happens then? So if you do a 20-day prelim for a mechanics lien, you have to record the mechanics lien at the county recorder's office in 30 or 90 days after completion of the entire project. And then to stop payment notices, you have to serve within 30 or 90 days after completion of the entire project, both on private and public. And so the reason I'm emphasizing of the project is because it's a little bit different when you get to the federal rules. And the other thing is, the reason it's 30 or 90 days is if the owner does a notice of completion or a notice of cessation, which means they've stopped the project for one reason, as a subcontractor or as anybody who does not have a direct contract with the owner, you've only got 30 days to record that lien or 30 days to serve the stop payment notice. And so those deadlines are very, very, very tight. So there's rules that talk about if they do a defective notice of completion or don't give you a notice of completion, you get more time, but don't worry about it. You need to act fast. If your work is done or you're done supplying, you need to be super diligent about getting paid, and don't fall down the trap where they say, well, the owner's holding retention, go ahead and do your lien. Because the owner holding retention is not the completion of the project. There's several different things that dictate completion of the project. So if you haven't been paid and you've been off the project for 30 days or so, I would start asking questions and recording liens if I had to, because you can always remove it. Not a problem. Pay me, I remove it. That should be your motto. Also on stop payment. So there's a couple things. Mechanics liens, you cannot record until you're finished with your work. And some people go, what about punch lists? That is a very gray area. And so if you've finished your work, except for miscellaneous punch list items or a couple of warranty issues, you should be okay recording a mechanics lien. If you record a mechanics lien too early and you're still supplying materials, or you ship one more thing, or you do one more little change order, it's a premature lien and it is invalid. So you would have to do another lien within this required deadline. So let me repeat that. You are not supposed to do a mechanics lien, record it until you're either done with your contract or you've been terminated from the project and you do not plan on coming back out there, or you do not plan on shipping anything else out there. Stop payment notices are different. You can do them as many times as you need to during the course of construction. And what that does, remember, it stops the owner from paying the general contractor. So you will get attention very quickly. If you do a stop payment notice for $10,000, the owner is obligated to hold back 125% of that. So it'd be $12,500 or something. So, and that starts eating into the available cash for the general, and you'll get your issue resolved very quickly. If you have change orders that they gave you directives and you never got it signed and they refuse to process it, a stop payment notice is a beautiful way to get attention and focus on the change orders that they owe you. Maybe they're 2 months late with payment plus another 50 grand of change orders. I would do a stop notice on that entire amount. And then again, all you have to do is release it once they pay you. And let's see, what else was I going to say? Oh, the other thing about stop payment notices is the reason you want to do those early and often is because if there are no more construction funds, there's nothing to stop payment on. They're gone. So it's as easy as that. A stop payment notice, in my opinion, is one of the easiest things anybody can do who has properly done their 20-day prelim, or who has a direct contract with the general contractor. Again, just do the prelim and don't worry about it. You can do a stop payment notice on the lender as well, and the construction lender or the mortgage company or whoever's financing. And they don't have to hold back money, but they usually do, unless you bond the stop payment notice. Do not get that confused with all the other bonds that are out there. That's another whole seminar. But anyway, that's a good thing about stop payment notices. Payment bonds, one more thing, if there is a lender and you bond your stop payment notice and they foreclose, even though you might lose your mechanics liens rights depending on when they funded, your stop payment notice still attaches to the construction funds if you've bonded it, even if they foreclose on the property. So it kind of has some power there. I'm not sure that this, the current financial state we're in right now would dictate that you really should bond your stop payment notices if there's a construction lender. But I'm telling you, I had a lot of clients who saved their businesses by doing bonded stop payment notices when we hit the 2008 through 2010 fiasco in construction. So you really need to understand these rights so you can take advantage of them. Payment bonds. Oh, and then on mechanics liens, shoot, I keep hitting my screen. Mechanics liens, you have to file a lawsuit within 90 days of recording your lien. Otherwise, it's stale, it's ineffective. So if you got done with your work early on and you lien the project and then you forgot about it, you're like, oh crap, I didn't do it within 90 days. So long as you still have time-wise lien rights, like the project's still not over or the project hasn't been over for 30 days or so, you can re-lien it. And so you do need to be diligent on that, because the other thing that you do not want to fall into the trap is the customer telling you, oh, or the owner telling you, oh, we're going to pay you next week. We'll pay you next week. You'll pay you next week. All they're doing is waiting for that 90 days to expire. And then they're like, oh, we don't owe you any more money. Owners do that all the time. So they'll wait for your lien to get stale, and then they no longer are obligated to pay you under that lien. So don't let that happen either. So stop payment notices, you have to file a lawsuit on to enforce your stop payment notice within 90 days of the last day to serve. So it's like, why couldn't they make this easier? So remember, your last day to serve a stop payment notice is either 30 or 90 days after the completion of the project. Then you have 90 days after that last day, not the day you served it, but the last day you could have served it. So your lawsuit has to be filed anywhere between 120 or 180 days after completion of the project, or a cessation of labor, meaning they're not going to finish the project. See, this is why people hate mechanics liens and bond rights and stop payment notes. It's these goofy schedules that that our people in Sacramento put together on how to save these rights. Payment bonds are different for timing wise to enforce if it's a private project versus a public project. You have to file a lawsuit on a payment bond within the time frame that's stated in the bond itself. And you're not going to know that until you get a copy of it. And you're not going to get a copy of it if you're not being paid. It's hard to get a copy of it even when you are not being paid, but at least get the bond company and the number right when you're opening up your job file. For a public project that's dictated by statute, you have to file a suit within 6 months after the time that you could have filed a stop payment notice. So you don't have to file a stop payment notice to have payment bond rights. They just link the deadlines together. And so that means you have 6 months plus 30 days or 6 months plus 90 days after completion of the project. So this is another very, very, very good reason to do this stuff early as you know that you or have any inkling that there's a problem about getting your retention or any payment or your change orders paid. For federal projects, if you have a contract directly with the prime contractor, you do not need to give any special notice. If you are a lower tier supplier or subcontractor, then you have to give the general contractor a 90-day notice. So that notice that you haven't been paid yet and you plan on going after the bond has to be done within 90 days after you last provided your materials or labor. And again, don't count on little punch list items to extend that date. It's the date you last provided materials and labor, not when the contract is finished. Same way, under federal projects, you have to file a lawsuit within 1 year after you last provided materials and labor. Remember, in California, you need to do all your liens and stop payment notices and bonds based on when the project itself has finished. Not so in federal law. It's when you last did your work. And a lot of people get tripped up on that, and that's how they miss deadlines one way or the other. That is the end of the slideshow. That only took a half hour. Thank you for the questions in between. But I can answer any more particular questions that you have on timing, purpose, any of those things, if you happen to have any questions. Or you can ask questions about the contracts.
This is Vanessa again. I do have one more question with regards to the mechanics liens.
Sure.
You said that you can re-lien, so that means there is an expiration of the lien, and I think I missed that critical piece of information. So you lien a property because you haven't been paid. When does it expire, and is it based upon the date that you filed the lien?
Yes, absolutely. It expires 90 days, not 3 months, 90 days from the date you recorded or filed your lien at the county recorder's office. You must have a lawsuit filed within those 90 days. If you miss that deadline, and if you miss that deadline, but you still have not missed the overall deadline to actually record a lien for example, maybe the project just got over a week ago, or it's not over yet, but you're done with your work, you can actually re-record a lien. Just do another mechanics lien, record it.
Okay.
And so the only way you would not be able to do that is if your 90 days expired and yet the deadline for all liens had also expired. So let's say you wait to the very last day and you actually record your lien on the 29th day after project completion, and then you wait the 90 days. You're not going to be able to re-lien it because the overall deadline for all liens has now expired.
Okay.
I hope that makes sense. That's a little bit hard to explain in words, actually.
I think I do have that.
Yeah, and so if the project's still going and you recorded because you got your work done pretty early on and you expired, lien it again.
Okay.
If you're really close and you know other people are still leaning, lien it again. And if it's late, it's late. They make that defense and then you can release it if you're wrong.
Okay. Thank you.
I mean, because they'll tell you, oh, we finished this thing 45 days ago. You're too late. Well, you know what? Prove it. And prove that they did a timely notice of completion, et cetera, et cetera. So don't ever not lien because somebody who, like the owner or the general contractor, is telling you you're late. I would lien and ask questions later.
Okay.
That's just, how they say.
Got it. Thank you very much.
Yeah.
Pam, in regards to the 20-day prelim notice that's sent out, what is a good way that they can explain to their customer what that is? Because I know sometimes they're not fully understanding of what it is, or they think that it's an actual mechanic lien when that's not what it is. So what's a good way for them to approach that with their customers?
That's a good question. So basically, it's there to protect the owner of the property so that they do not have liens on their project after they pay the general contractor. It alerts the owner and is really a protection for them, like I said, because they want to make sure that all the subs and suppliers are also getting paid. And so it's a good way for them to understand who's on their project, how much work they're doing, and the value of that work. And it is not a lien. And as a matter of fact, by law, if you are a licensed contractor, the Contractor State License Board requires you to send out a preliminary notice to people's projects. It's required. And so I would explain it that way as well. If you are working for a general contractor and you're entering into a subcontract with them, and they tell you don't lien, the owner will freak out, that's a red flag, because any contractor who's legitimate, in my opinion, will understand. They would have already explained it to their customer, the owner, what it will mean. They would actually sit down with their owner and say, hey, once we start the project, you're going to be getting preliminary notices. And it doesn't mean these people are leaning or these contractors are leaning. It really means that they're letting you know they're out there. It lets you know an approximate amount of the work they're doing. And it gives you the opportunity to make sure they're paid, because you'll be able to get a variety of releases from them. So a good general contractor would sit their customer down and explain that whole process with releases and everything. So, but I mean, we've Shannon, you and I have worked together to try to figure out, can we do a cover letter that explains that? Interesting enough, the company called Level Set has a very interesting looking prelim. It basically starts out by saying something like, oh, we're introducing ourselves, we're going to be on your project. It's a very friendly thing. But if you read the whole thing, it eventually does put all the language it needs to have in there. But it's a very soft step on how that company, when you hire them to do your prelims, what they say to the owner of why they're getting that document. And that you do need to do it certified, return receipt requested, by the way. Don't ever just mail them. I'm sure you all know that, right? So anyway, good question, Shannon. But again, it's hard to make, especially homeowners, if you're doing any residential work, or unsophisticated tenants who are just for the first time handling their own tenant improvements in a building or something. So.
Thank you.
You're welcome. Hopefully I answered it.
Yes.
Anything else? People are dropping like flies. No, I'm kidding. I just saw somebody drop off.
Well,
I
thank
know
you so
liens
much,
are
Pam.
boring. I have found no way to make it exciting.
No, great job. Thank you.